start the weekend. We can't do that unless I'm going to consider it. 314 comes along, and here come the tomatoes. Okay, we're going to talk about defending the ID case. But I don't want you to look at it just from the standpoint of defending the ID case. What we're going to do here is an example in doing the ID case of what you can do with the different kinds of cases that you finish, that you see with some degree of regularity, okay? I'm saying that once I did this in the ID case, then with some fairly minor variations, I could use this again in the next ID case, and again in the next ID case, and again in the next ID case. I'll tell you something that might be of interest to you. In spite of the fact that I'm doing it against the same DA's office or ones that were connected, they never caught on to the fact that I was doing pretty much the same thing over and over again. So that tells you something about the opposition. Okay. It is a way to build a kind of case. There is already a theme and a theory that is there, and you just change some of the things that correspond to the facts. Now, how did this all happen? Well, I'm going to tell you how it happened in this particular case. It was a murder case. Right next to East High in Denver, across the street, was a mom-and-pop grocery store. And one day, somebody came in, obviously not my client. Somebody came in and robbed Mom. Pop was in the back where the couple lived, and he heard some sort of commotion or something that attracted his attention. He comes out there and makes a mistake, and I am sympathetic to this. He goes for the gun, which is under the counter, and of course gets shot. And so we have a murder case. Now, it wasn't just a murder case. This man had been passing, this couple, had been passing out to the East High students who couldn't afford candy, etc. They would give it to them free. So he was known as the Candy Man. And you can imagine the letters to the editor, etc. over the Candy Man being killed. The one thing I was confident of is that this is one of those instances in which I was representing somebody who was innocent. When I met the defendant's brother, I said, here's the guy who meets the description. He is the one, I believe, who committed the crime. So I've got the one in the family who had in his billfold newspaper clippings from the murder case, and had been caught with a gun and several other things. But the description of the robber or murderer was 6'2", 180 pounds, etc. And my little guy was 5'10" and 160 pounds, which shows you how far off they can get. But I was concerned, and it happened, I was in the public defender's office at the time, and it happened that things gave me time to think about the identification case. And the question after a while in the brainstorming process was, how is it that right after a robbery, murder, whatever it happens to be, that the identification witnesses are so uncertain, but by the time they get to court, they say, he's the one, and I'm absolutely certain. Now, this is in disregard of all the rules of memory, right? They should be able to remember best at the start. Okay? I want to keep you in suspense a little bit as to how it is that this occurs, but that was the question that existed. Let me back up a little bit and talk about the identification case for a second or two. The identification case, I say, results in more misidentifications and therefore the conviction of innocent persons than any other kind of case. There are false accusations, knowingly false accusations in sex cases, etc., but there are more just plain mistakes. That is, the eyewitness believes this is the person who did it, and it isn't. Even if I know that the defendant is guilty, that is the right person, I don't have any trouble whatsoever fighting the ID case. Because there is so much that goes wrong. There is so much suggestion. I remember one case where they held a lineup, and I think I showed up a little sooner than they expected. And here's the police officer. They're talking to the witnesses and joking with them about the defendant that they were going to put in the lineup, and was talking about his characteristics and all of this kind of thing. I then became a witness in the case as opposed to somebody who was defending the case. But if I hadn't shown up at that time, no one would ever have let me know about what was happening. I have gotten detectives to admit on the witness stand. This makes your heart go a little faster, okay, when you're asking this kind of question. It's true, isn't it, detective, that it's not unusual when you have a lineup for the witness to pick somebody who couldn't possibly have committed the crime. And they hesitate, and they say yes. Okay. I have made a judgment as to which ones will say yes, and I don't ask the ones that would say no. But it is true. In attending lineups in Denver, what they do is to get the fillers out of the jail. It's not at all unusual. Here's somebody who's been in jail for 3 days, and the robbery occurred last night, and for witnesses to say it was the person who had been in jail for 3 days. So, identification evidence is bad evidence. Let's just start with that. But we know we are facing the situation where the witness is pointing to the defendant in the courtroom and saying, he's the one and I am sure. What we know about certainty, that is, that someone is certain of something, is that there isn't any great connection between certainty and being right. And there are all kinds of studies that show this to be true. The toughest ID witness that I ever saw was one that was being cross-examined by a friend of mine. He was a druggist who had been robbed, and he was really, really tough. Why was he tough? Because he expressed so much care. I wanted to be sure. That's why I took the extra time and all this kind of thing. And I would much, much rather have somebody who is, I'm sure, and he's the one, and all this kind of thing. The druggist was a tough witness because he wasn't going to any extreme one way or the other. Okay. This is an example, the ID case, of what I was talking about the other day, and I'll just mention that briefly. Your legal theory, your factual theory is this identification. And the question is, how are we going to get this across to the jury? If you believe what studies do show, the jury doesn't believe in They're having to be proof beyond a reasonable doubt. They don't believe in the presumption of innocence. They don't believe in the prosecutor having the burden of proof, etc. Then how are we going to handle this kind of case? Because we're going to face that situation. He's the one, and I'm sure of it. Now, I'll mention this simply to get past it because all of you know this doesn't work. You have just pointed to Johnny Defendant here and said that he's the one who robbed you. Now, the truth of the matter is that you're not sure, are you, that he is the one who robbed you. And lo and behold, oh, okay, so yes, all right. All right, so what we're saying is a direct attack doesn't work, okay? I don't want to tell you it would never work, but I wouldn't count on it, okay? It is rare indeed that that's going to work. So what we are going to do is to undermine that identification. We're going to undermine, that's the process, okay? We are not going to directly fight the identification. We're going to undermine. Which means that we are going to get the evidence that the identification was not a good identification, was an erroneous identification. The position that we are going to take throughout the trial is they've got the wrong man, he didn't do it. Now, the reality is that that may not be strictly our position. It may be that what we're really doing is attacking their identification, which wouldn't necessarily make him the wrong man. But if we take the position they have failed to prove it, they failed to prove it beyond a reasonable doubt, that is going to be weak compared to taking the position that he didn't do it, they've got the wrong man. And there will be, in every single case, evidence, prosecution evidence, from which you can build a case against the real robber. I'm going to use robber here, okay, as generic for all of it. There will be evidence, the prosecution's own case, that somebody else committed the robbery. It will be, for example, in the description, like the one 6'2", 180 pounds, 5'10", 160. What does this discrepancy show? That there is a reasonable doubt? I hope not. Well, more than that. What it shows is that there was a big man who committed the robbery. The prosecution's own witnesses testified to that. It was somebody 6'2" and 180 pounds. And it couldn't be this young man. And so the prosecution's own evidence demonstrates that it couldn't have been this young man. Their evidence shows that they got the wrong man. Okay? Different position, okay? A lot stronger to do it that way. Does this make sense or not? Okay. You are taking it and you are turning that which some attorneys would say merely creates a reasonable doubt, and you are turning it into a positive case. You are prosecuting the real robber who is not in the courtroom. Okay? And you're saying that the real robber is out there someplace else on the basis of the prosecution's own evidence. Because the great majority of the time you aren't going to have evidence of your own. You're going to be depending on cross-examination of the prosecution's witnesses to show this. Okay? Make sense? We might as well deal here with a little bit with putting the defendant on the stand. When you put the defendant on the stand, the defendant's story becomes your theory of the case. Okay? There's temptation I've had at times to get up and say, ladies and gentlemen of the jury, my defendant took the stand and told you various things, but don't pay any attention to that. I'm going to tell you how it really happened, okay? That's only a temptation. I have never done that because of the obvious weakness of it all, okay? So, we're going to do it positively. We are going to have a block in our closing argument which says that the real robber is not in this courtroom. The real robber is out on the street, and the prosecution's evidence shows it. And then we have a positive case here where we are prosecuting. And we're going to say someplace along the line, here in Macon, Georgia, or Chicago, New York, San Francisco, Canada, Mexico, who knows where. There walks the man who is the real robber. A man who, okay, has the characteristics of what? Of the original description given by their witness. That description that does not fit your defendant. Make sense? Okay. That description which does not fit your defendant. If there is, and witnesses can't get it right. And I will tell you that if I were robbed, I wouldn't get it right. I would be scared to death, okay? But they don't get it right. And we're going to use the ways that they got it. You know, they may testify that he had a mole right here, something like that. So then, who do you prosecute? And your defendant doesn't have the mole here, okay? You're going to prosecute the man who has the mole right here. You're going to prosecute the bigger man, if that was the description. You're going to prosecute the smaller man, if that was the description. You are going to prosecute the man who had the mustache, if your defendant didn't have the mustache. Okay? You are going to find the characteristics of that original description which does not fit your defendant, and you're going to prosecute that person. Make sense? Okay? Understand why we are taking positive positions as opposed to the kind of neutral position that the prosecutor has failed to prove each and every element beyond a reasonable doubt. There is nobody, I don't care who it is, Albert Krieger, Jerry Spence, whoever it happens to be, who can make this there's a reasonable doubt case as powerful as that when you are looking for your positive case, prosecuting the real robber. Okay. Where are you going to get the information to ask about in the cross-examination of the trial? Well, you need to file a motion, Wade, Stovall, etc., so that you get a hearing. If you need to, subpoena the eyewitness. These cases, ID cases, are basically closing argument cases. And what we want to do is to gather information ahead of trial which is useful to us and which the witness has to agree to in trial. So we ask all kinds of questions on the motions hearing, and we find out what this person knows, doesn't know, what this person claims, etc., and you'll see what we're talking about in a few minutes, the kind of questions we're going to be asking. Okay? But your objective ahead of time is to get the information. In other words, have the witness pinned down so that you can ask the questions on cross-examination and you've already built your case. Okay? And they have to either agree with it or become inconsistent with what they have said before. Okay. Let's talk, having that in mind, with what is wrong with identifications. There is a book, by the way, by Patrick Wall, where he just deals with eyewitness identification. Some of the things I'm going to be talking to you about come right out of that book. he talks about it in a way that I find useful, and therefore I'm going to talk to you. What are the red flags to identification? The red flags that indicate that we have to be worried about whether this is an accurate identification, true identification, or is a mistaken identification. And here you can give me some help as we go along. What are red flags? The things that, when they occur in the facts of a case, are likely to be indicative of mistaken identification.
More than one lineup.
More than one lineup.
Or photo line. Or multiple showings of different ones.
Okay, because
Reinforces the one picture that's consistent throughout them.
okay, so that's a part of it. All right, what else? Yeah,
An unduly suggestive lineup.
an unduly suggestive lineup. Okay. What else?
Crime happening fast.
The crime happened fast, and as a result of the crime happening fast, what has occurred?
Inadequate opportunity.
Inadequate opportunity to observe. Let's stick with this one for just a little bit because it has various facets, okay? Inadequate opportunity to observe what has occurred. Let's say it's a liquor store robbery. The person comes in, goes over to the beer cooler and so forth, and he's there for a little while, and then he orders a bottle of gin or what have you. The clerk turns around, gets it, turns around to face the 38 or whatever it is. Okay? Well, wait a minute. The person has been in the store for a while. So we've got, let's say the person's been in the store for 5 minutes. That's 5 minutes of observation, isn't it? No? Okay, because
No reason.
no reason to be paying any attention. Right. Okay, there are distractions. And they've had how many customers that day? 267 customers or something like that. This person didn't attract any attention. Otherwise he would have called the police, right? Okay, this person didn't attract any attention. So what are we doing? We're taking the identification that occurred in your particular case and putting it under a microscope and examining it in detail. I mean, we are really doing a microscopic examination as opposed to this whole thing. Okay? What else is there as far as opportunity to observe?
Attention on the gun.
Okay? Weapon focus. Right. And do people do that?
Oh, yes.
Well, you bet. Would I do that? You bet. Been there, done that. I would be looking at that gun. And they're able to tell you the color of the gun. They're able to tell you all of its features, all this kind of thing, because that's where they're looking. All right? So that's another one. What else? Lighting conditions. Lighting conditions important. Because many of these places are not designed to have light that would really be very useful. Okay, what else?
Your position, proximity, how close, how far.
Okay, how close, how far? All right. What else? Yeah. Okay.
Intentional acts by the robber to conceal his identity.
Okay. And so, you know, masks or anything like that, or even putting collar up or what have you. Now, be sure when you're dealing with this kind of thing not to come across that it was your defendant
Behind the mask.
but and I have watched people do this over and over again. Well, you didn't see him because there was a mask. You didn't see him because of this, that, and the other thing, and it sounds for all the world as if the attorney is recognizing that it was the defendant, but you can't pick him out because the person had a mask on or whatever it happened to be. So your position from which you are doing this is that it was not your defendant. Yes, the person had on a mask or whatever else. Ski mask pulled down or whatever. But it wasn't your guy. But that helped to result in a false identification of your guy, right? Okay. What else as far as, yeah?
Now, drinking. Witness drinking, ingesting drugs, partying.
Yeah, anything whatsoever, okay? Anything whatsoever that's going to cause that jury to doubt the witness, because it's all on the witness, isn't it? Maybe, obviously, there are cases with circumstantial evidence supporting it and so forth, but they've been on drugs, they have been drinking, they have been up a long time, they were this, that, or the other thing, whatever it is. And it doesn't take all that much to win with the jury. We talked the other day about the fear of convicting an innocent person. So we're going to get to the closing argument and we're going to say the prosecution's case depends on whether Mr. Campbell was right. He's wrong. And you convict on his testimony just because he pointed to this young man and said he was the one. You convict on that, you will have convicted an innocent man. So you're going to try this case on the basis that your God is absolutely innocent. Okay. All right. Other things. Yeah.
Cross-racial.
Yeah, because what do the studies show you? Tonight?
Yeah, the studies show that when a person is from a homogeneous society and they're viewing someone else outside of their homogeneous society, they're more likely not to notice features or not to recognize specific things, and it's just like, all black people look alike or all Asians look alike.
Yeah.
Well, some matter of fact, hairdo makes them real.
I haven't seen this recently, but did I miss something here?
I just commented, some people's hairdo would make them real conspicuous.
If you and I are going to do a robbery, we'll work on it. I was talking at lunch about a guy in Denver named Benningfield. Benningfield is about 6'8" or so. He is really, really thin. I mean, he is just a little rail is what he is. His face looks something like Abraham Lincoln's. It's really unusual. And does Benningfield ever bother to wear a mask when he does the robbery? The last robbery of a bank that he did, they said, Benningfield, get out of here. I need to talk to him sometime. He is just not qualified for this job that he is attempting. Okay. What else? Okay, yeah.
Can I ask you just a quick question about the last one?
Sure.
Is there any way to bring out that evidence without having an expert and bring out the fact that there's this cross, that white women identify black, black women identify
Yeah. The advantage, and I got expert down the line, but we'll talk about it next. The advantage of the expert is that it does focus on cross-racial identification and that kind of thing, and gives some figures. I think it's mistakes are about 8 times as likely if it's cross-racial, and it gives you the chance to make the argument. But I have done it without experts, saying things like everybody in this courtroom knows. Okay? Or use some wolves studies show during voir dire, and that's your favorite expert.
So it's just something for argument in that way.
Yeah. And this is not to put down using an expert.
Well, it can't, it's just not an option. So I had a case recently where it was definitely an issue, and that was the struggle. We couldn't do an expert.
Yeah. And there was a time when I was in the public defender's office when we couldn't get an expert paid for, but if you adopt the chutzpah theory of advocacy that I do, you just go ahead and argue it as if it's true. Which wins cases, by the way. Okay. So when I have opportunity to observe the conditions, short time, lighting, he didn't observe before notice, surprise, weapon focus, and then we're really dealing with condition of the victim or eyewitness, emotion. I mean, they'll all admit that they were scared because if they didn't, they wouldn't have any credibility. The fear, anger, scared. Some of them may have physical problems that you can find out about. They wear glasses. They weren't wearing glasses at the time. That may affect them. Mental, drugs, alcohol, sleepy, any other identification relevant condition. Okay. Actions showing doubt about the identification. Even if it's not in the eyewitness's mind, in the jury's mind. Vague description. The vague description is going to be useful to you because in virtually every robbery, now let me just go farther, every robbery that I have ever seen, what has been there is if there is a detailed description by the eyewitness, they will be wrong or they will be giving description that does not fit your defendant. If there is not detailed description, it is then a vague description. Vague description, term of art here, okay? Meaning things like, I think he had on, he was close to 6 foot tall, not sure whether it was 5'10" or 6'2". I think he had on jeans, or I don't know whether he had facial hair. All of this kind of thing. And there are those that, of course, are somewhat more definite than that. But it is when you take the position in your own mind, there was a vague description, and you go searching for that vague description, and you will come up with it. Okay? And virtually every description given to the police is really a vague description. Why? I think the main reason is that they were scared, and they were focusing on the weapon. They weren't focusing on this person. And I will tell you, I would be so scared that I wouldn't be able to do much with the description. So, the vague description. The vague description cross-examination you're going to need, okay? And it goes something like this. Jones, detectives were talking to you after this.
Yes.
And you've just been robbed.
Yes.
So you wanted to do everything you could to help the police.
Everything.
Matter of fact, not to say that there was anything wrong with this, but you were angry about the fact that you were robbed.
Very angry.
Okay. So we got some emotion here. And so when the police were talking to you, they had a form there, right?
Yes.
And every time you give them an answer, you wrote it. Okay, so the police officer wrote it down.
Yes.
And he asked you about various things like hair,
Uh-huh.
facial hair,
Yes.
glasses, beard, all that kind of thing, about what kind of clothes he was wearing, and so forth. And you gave him all the information that you had.
Yes.
Because you knew that the more information you gave the police officer, the more it was helping the police officer catch this robber.
Yes.
Okay. And then they end up with something that's vague. So they have attempted, okay, that's what I call a vague description cross-examination. It's a block of your cross-examination. the witness has done the best that he or she can, and still we only have things that fit half the population. Okay? It's really a generic description. And you are going to use the fact that there was only a vague description as part of the weapon that you have in the ID case. Okay? Because if this person had seen the defendant so well that he can be so sure now, then right after this occurred, this person would have been able to give a far better description. So you use the fact that there was a vague description as evidence that we can't trust this identification. And we're going to scare the hell out of the jury about the possibility of convicting an innocent man. Okay? Words of doubt. Words of doubt. Right after it happens, the detective may ask the witness, if you saw this person again, would you be able to recognize him? Okay? You see what we're having to do? We're having to take the words that were said during all of this identification process, because any words that are other than, this is the person and I'm absolutely sure of it, we are going to take as evidence of what? Uncertainty. Okay? Because it is. So when they show the witness 6 pictures of what happened, and the witness says, this looks pretty much like him. This looks like him except for the nose. This looks like him. This looks like him except that he seemed to be a little older. Any hedge whatsoever we take as evidence of what? That this isn't the person. Okay? We're looking for evidence of uncertainty right after it occurred to contrast with the words of certainty here in this courtroom. He's the one and I'm sure of it. Because when we get to the closing argument, we are going to focus the jury's mind not on what happened here in the courtroom, but we're going to take them back to the time right after it occurred and the uncertainty then. Okay? Now, words of doubt. Any words whatsoever. I'm not sure, but I will try. This looks like him, but we are going to take as evidence of uncertainty. What about the lineup? They hold a lineup. And there's a procedure, right? Depending on your jurisdiction, they turn this way, they turn this way, they turn around, they walk around in a circle, they do this, that, and the other thing. And you ask the witness during the motions hearing, when was it, Mr. Jones, that you decided that it was Johnny defendant in the line? Now, if they say right away, we are going to be working on, he jumped to a conclusion, he wasn't careful, he didn't look, etc. But I will tell you that I don't think people are as successful with that as they are in getting the witness to say, well, about 2/3 of the way through, which seems to be a favorite answer. Okay? Well then, wait a minute. We have had all of this routine, which of course you stretch out. Okay, about turning this way, turning that way, we got to speak it slower. Turned around, walked this direction, walked around in a circle, all this kind of thing. We slow it down so it lasts longer. And 2/3 of the way through. What is that evidence of? Uncertainty. Now, there are really only 4 answers here today, by the way. And I'm just kidding you, I'm not. So the other two will come up. But all the evidence that we can find of uncertainty, like a vague description, like words of uncertainty, like anything whatsoever that indicates uncertainty, because that's what we're building. Now see how your case gets to be so much stronger when you know precisely what your goal is, which is to show uncertainty right after the event. We don't have to worry about the certainty in the courtroom. The prosecutor will take care of that, you know. He's the one, and I'm sure of it. But it's the contrast that makes the difference. Some other things that are red flags. Talking to others. The witness talked to the other employees at the place, and they compared notes. Why are they comparing notes? If you're sure, you don't have to compare notes, do you? Now you can argue, well, of course, this is an exciting event and all of this kind of thing, and that's fine for the prosecutor to argue that, but you're going to take the position that this is what occurred. These people weren't sure. They all got together. They tried to figure it out together because they were uncertain. Okay? Anything whatsoever becomes evidence of uncertainty, and you take the chutzpah position that that's what it is, and you do it with strength. When they take the cue from others, if you can get any kind of admission that somebody else decided it was a certain way and they went along with it, okay? And you just try these things out during the Wade hearing, right? You can ask all kinds of questions because you're doing what we talk about as the panning for gold. I'm from Denver, okay? So I'll just panning for gold and let you apply your own. What did the old prospector do? He dipped down into the stream and he got all kinds of goop, right? And he shook it down and he was looking for a nugget. And you are looking for nuggets during that Wade hearing, okay? And you ask all kinds of questions to see what you come up with. And then what you're going to do is you're just going to keep the nuggets and throw the rest of it away. Make sense? Okay. Even you Easterners got it? They're taking the cue from others. Anything whatsoever. You decide how to put this together. Okay. The next one. Talking to the district attorney about the case and changing their testimony. Does this occur? Okay. They have talked to the police, and you've got it in the police report, and then when they talk to the district attorney, and the district attorney gives them some hint that it would have been better if they had said X rather than Y, what do witnesses often do? Change their testimony. Even if the district attorney doesn't tell them to change the testimony. Because after all, they're convinced that they got the right man, so we'll say what is necessary. Okay. When you can get that kind of thing, look at what you've set up for the closing argument. And ladies and gentlemen of the jury, before we talk about these cases, maybe we ought to talk about the fact that this witness told the police A, and then talked to the district attorney, and after this witness talked to the district attorney, the witness changed his testimony. That's the kind of case that they want to rely on to label this man a robber for the rest of his life, okay? When you, and they do it with regularity, search for this. I mean, you have to actively be aware of it, okay? The witnesses have changed their tune after talking to the district attorney. Now, you have no proof that the district attorney suggested a change in testimony. That's fine. The jury will draw the conclusion when you line this up that they told the police one thing, talked to the district attorney, and then changed the testimony. Okay? The jury will decide the DA is playing games. Sometimes you actually get to accuse the DA of playing games. Okay? So the change in testimony. Wow, that's great stuff. Over and over again, you can win. Inconsistent statements by the witness. Look for the inconsistent statements. Now then, here once again, we do not want you to be lawyers, right? Being a lawyer is a tremendous disadvantage, because if you are a lawyer, you are going to say to the jury that the witness Campbell had inconsistent statements. And the jury is going to say, so, right? To us, it's significant, right, that there were inconsistent statements. To the jury, it isn't significant. So we have to have a better way, don't we, of communicating to the jury what this is all about. Inconsistent statements by this eyewitness shows what? Give me some other words besides inconsistent statements.
Change your mind.
Change your mind, okay?
Inability to remember.
Oh, but that's kind of lawyer-like. Okay, yeah. Okay, liar, okay, but probably the person, huh? Wrong. Oh, I like that one. I like wrong. Mistake, etc. When the you work from the beginning, motions hearing, preliminary hearing, wherever, to get inconsistent statements, because you are setting up those inconsistent statements, and you're going to have a block in your closing argument, right? You do things by blocks. A block in your closing argument where you say, ladies and gentlemen of the jury, the prosecution's case depends on Mr. Campbell, and Mr. Campbell being 100% right. Let's see whether Mr. Campbell is 100% right. As to subject number 1, he said orange one time and yellow the next. Mr. Campbell was wrong, wasn't he? One time or the other. As to item number 2, he said green one time, blue the next, and purple the next. He was wrong, wasn't he? At least 2 of the 3 times, and maybe all 3. As to whatever it is, it's number 3. Okay, get the idea? Wrong, 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 wrong. And then the punchline. And ladies and gentlemen of the jury, should you convict and label this young man a robber for the rest of his life on the testimony of Mr. Campbell, and it turns out that he was wrong when he pointed to Johnny Defendant, like he has been wrong on each and every one of the 5 things that we just discussed, showing that he has been wrong 5 times at least. If it turns out that he was wrong when he pointed to Johnny Defendant, like he's been wrong on these other things, and you convict on that evidence of Mr. Campbell, then you will have convicted and innocent. I had a judge one time saying, that's being awfully tough on the jury. And I told the judge that that was the idea. You want to make it so that those inconsistencies and this witness being wrong, 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 wrong is going to make it so that the jury is afraid to convict because they will be wrong and convict an innocent man. So you're searching for inconsistencies from the very beginning of the case, and of course that's an indication of something wrong with the identification. Inconsistent with not only themselves, but the outside. Inconsistent with other witnesses. As to the lineup or the photo display, other witnesses did not pick the same person. Inconsistent with physical evidence. When I was in the public defender's office, I'd send the investigator to take a picture of the scene, and they would say to me, "What do you want it for?" That's so wrong. I don't know yet. But the one thing you can count on, the witnesses will testify to things which are inconsistent with the physical evidence, okay? They will. And your attempt is to create what? Doubt on the part of the jurors. Doubt, yes, and maybe even convince them that somebody else was the robber. That's the position you're going to take. I had one time where there was a description of a fight going up and down this alley. And I went out there figuring that there was a house that was, a vacant lot or something. There was no vacant lot. He's on this particular street. There was a time in Denver when they could build the houses 18 inches apart. And so he couldn't possibly have seen this. I do not know to this day what was going on. But we got all of this description of this fight with this guy who was trying to get away. The robber was trying to get away. Of taking place in the alley. We had a picture of this. No, and he's really through. So, you are trying to make it so that the witness's testimony is what I call run up on the rocks. That is, you find physical evidence of some sort that the witness could not be right. You are destroying the jury's confidence in basing their judgment on this witness being right by showing in as many ways as possible that this witness is wrong. Make sense? Okay. I don't know by the witness. I stumbled onto this accidentally one time. The more you can get the witness to say, "I don't know," the better off you are, right? I mean, are we going to, if we're a juror, we're going to depend on somebody who says, "I don't know, I don't know, I don't know." Now, here's the way you do it. You need a couple of inconsistencies by the witness. That is, things that they said before. And now you give them a chance to, okay, they said A before, and now they say non-A. And what do? You get them with the inconsistencies. This is what they said before. If you've got two things like that in a row, and particularly if they have told the cops one thing, another thing at preliminary hearing or during, okay, then they have to be wrong, right? One time or the other. So you're going to hit them with a couple of inconsistencies, and then ask them a question to which the natural answer would be, "I don't know." And they give you the "I don't know." And then you say, "Nice witness." Mr. Jones, I understand it was a stressful time, and we really appreciate it when you don't know if you tell us that. Okay? And you give him other opportunities to say, "I don't know." And amazingly, these witnesses, in no time at all, will find that they can be good friends with you if they say, "I don't know." Okay? Terry McCarthy's, whoop, whoop. And it's really true. And they will say, "I don't know." They have learned this is the easy way around this whole thing. And then you've got the argument and closing argument. See how you're building, everything you do is really building for closing argument. Okay? And you've got the argument closing argument that they didn't know about A. And they said, I don't know as to B. And they said, I don't know as to C. And they said, I don't know as to D. And this is the person the prosecutor would have us use as the foundation of labeling this young man a robber for the rest of his life. Okay? So I don't knows are a pretty darn good way to go. Now, the way that it gets from uncertainty to certainty is a process of suggestion and reassurance. And let's see if this isn't true. I believe that the reason that this method works, and so far, haven't lost a case using this method, all right, and not you case. The reason that it works, I believe, is that this is true. That is, it is through a process of suggestion and reassurance that we go from the uncertainty right after the event to certainty in the courtroom. Okay? Play the game with me just a little bit. So, right after the event, many of the witnesses say to the police officer, when will I hear from you? Or something to that effect. Police officers are busy and they say what? Don't call us, we'll call you. In so many words. But even if that conversation does not take place, the time comes when the police call the eyewitness. And you can ask the eyewitness, what did you think when you received that phone call? And what's it going to be? They got it. Yeah, they got it. And if you do this softly, at the wait hearing, what have you, you will get that answer over and over again. I thought they got it. Because that is the way. You see, the witness is not thinking like we would think. The witness is thinking like a witness. So you'll see as we go through here, there is a certain way the witness thinks about the police as knowing what they're doing, as being the authority figures. They do not think about the fact that the police were not at the robbery. They think when the police calls and says, would you look at some pictures, they have caught the man. So they come over. And there are different ways that this occurs depending on your jurisdiction, but I'll just use a way it's often done. So we've got 6 pictures, and we spread the pictures out. Some of them are put in a circle, whatever, in your jurisdiction. The person goes along and looks at 1, looks at 2, looks at 3, puts his finger on 4, looks at 5, and looks at 6. What's that evidence of? Uncertainty, yeah. Only 4 answers here. It is evidence of uncertainty. Why? Because if he was sure it was number 4, he wouldn't look at 5 and 6. When you ask them why they looked at 5 and 6, they will say what? To be certain. To be sure, that's exactly it. I mean, this is all human nature, and it occurs virtually the same every time. Okay? Now, if they stop at 4 and don't look at 5 and 6, what are we going to do? They jump to a conclusion. They didn't care. They just jumped to a conclusion when they came to number 4. Not as good as the other. I like the other much better. So if you can lead them along the path of going to 5 and 6, and then ask them if they happen to notice the expression on Detective Taylor's face, when they picked number 4. And the answer is what? They did. Why did they notice the expression on Detective Taylor's face?
They're looking for approval.
They were looking for approval. It was a game. Now, to show you how important the words are here as reflecting the process that's going on in the witness's mind, they will often be telling you, as a matter of fact, darn near every time, when they were looking at the pictures, that the detective wanted to see if they could pick him out. Okay? The witnesses don't have the idea that the photos are put there to see whether the robber is among them. The witness has already decided the robber is among the pictures, so that the police, by reducing this down to 6 pictures, has taken the universe of possible robbers and reduced it to 6. Okay? Now this process we're going to tell the jury about. We're going to say, how did it happen that it went from uncertainty right after the event to certainty? Let's look at what happened in this particular case. So what I'm telling you is really the closing argument, okay? Put in closing argument terms, but it's not very different from this. They have noticed the expression on Detective Taylor's face. And what was that expression? He seemed to be pleased, or something equivalent to this. And then the detective does what? Says, would you sign the back and date it, or next to it, or whatever is done in your jurisdiction? Mr. Jones, when the detective asked you to sign and date it, did that reassure you that you had picked the right person? And they will give you a yes answer with regularity, because that's what's going on with the witness. So you see, it's just a little game with the witnesses to see if they could pick the right ones. And then they're looking to the detective, because the detective is what? In the area of identification, the detective is an authority figure. The witnesses truly believe that the detective knows whether this person committed the robbery or not. Next time when you're examining them at a preliminary hearing or what have you, ask these questions. You will see this is a process that occurs over and over and over. I don't mean part of the time. I mean almost all of the time. They jump to the conclusion that the robber is among the 6 pictures. They then check with the detective, look at the detective, to see if they picked the right person. And then the detective says what? Would you be able to pick this person out in a lineup? And what do? Yeah, they study the picture. And then tomorrow, guess who is the only one among those in the photos who happens to also be in the lineup? Happens to be Johnny Defendant, who is there. And then they do the lineup, and that's where if it takes them 2/3 of the time before that's evidence of what? Uncertainty, yeah. We want to know what words they said, because anything other than I'm absolutely certain that number 3 is the one, or number 4 is the one, that becomes evidence of what? Uncertainty once again, okay? So we've got the photo display out of the way, we've got the lineup out of the way, and we have been gathering evidence of uncertainty. And then there is a time when they are subpoenaed. What does that tell the witness? Yeah, got it right. I mean, they cannot imagine. Witnesses cannot imagine that it would have been allowed to go this far along the line if they were making a mistake. And so they received a subpoena to appear in court for some sort of hearing. And then guess what happens at the hearing? The judge rules that the identification evidence is admissible. I mean, someday, some judge may rule to the contrary. We actually had a lineup in Colorado where they had a black among all whites, believe it or not. And I will give the court credit, they did reverse that one. Now, here we are getting ready for trial, and they're giving a subpoena. Does that suggest they've been right all along? Does that reassure them that they've been right all along? They come into court, and here they are taking an oath, and they're on the witness stand and so forth. How can there be any doubt anymore? And so it is, I keep picking on you.
I'm probably guilty of purpose.
That's the reason I was picking on you.
It shows, huh?
He's the one, and there's no question about it. So, you have to deal with the fact that the jury didn't see the uncertain things back when. But they did see the certainty right here in court. In that closing argument, you're going to have to beg the jurors. And I use that term. Ladies and gentlemen of the jury, I beg you, when you go back into that jury deliberation room, with pencil and paper there are your minds. I beg of you, write down on that paper so that you can test it that there was uncertainty right after the event that became certain. And I suggest to you that the uncertainty is really what this case is all about, so I beg you to focus on the uncertainty. And you can put it up on charts, you can do whatever you can to get the jury focused on right after the event and the uncertainty. Because it does seem strange to the jury. But there would be all these indications, vague descriptions, saying, I'm not sure I could recognize the person, but I would try, etc., right after it occurred. And then they understand, and you're telling them that the way that this did occur was because whether the police meant to or not, what occurred was several steps, and it's worthwhile counting them out in your particular case. There are 7 different times that there was suggestion and reassurance. Is there any question about how it got to be? From uncertainty, right after the event, to certainty here in court, when 7 different times there was suggestion and reassurance. Not saying that the police meant to do this. This is the procedure that they have been taught. But it is a procedure that results in innocent people being convicted of crimes which they did not commit. Okay? Yeah.
What do you do with the case where you just can't get the witness to admit there's been any suggestion? I tried a case with 3 eyewitnesses and they said,
Yeah.
we didn't think of
Yeah,
that.
but did you notice that every step of the way here I haven't asked the witness whether there's been any suggestion?
Right.
Okay? This much you know in your case. Okay, you've established the uncertainty, etc. Okay. That there is a photo display. And during that photo display, if they have, and maybe you're going to be really tough on me, they didn't even say any words whatsoever of uncertainty, like, this looks like him, or anything like that. Okay? Notice that we're never asking the witness whether there has been suggestion or reassurance. Those are conclusory words. They will not get you what you're after. You are coming up with facts from which you can argue that there is suggestion and reassurance. And as I said to the group this morning, don't tell the Supreme Court. Under oath, right? You're not going to tell the Supreme Court because they take it away from us. We get to argue facts and what? All reasonable inferences therefrom. Okay? Our opportunity to win criminal defense cases depends on our being able to argue the reasonable inferences therefrom. Okay? So we can put together how we say this happened without a shred of evidence where anybody says there was suggestion or reassurance. We can put those labels on it because of what happened. That is, the mere fact that the police officer called up this witness and said, we'd like for you to look at some photographs. You don't even have to get anybody to admit that there was suggestion in that. You can argue it to the jury, because the jury is going to say, of course, if I were in that situation, I were an eyewitness, and the policeman called and wanted me to look at the photographs, I would conclude that they have found the person. See, now, if you can get some additional evidence, that's better yet. But if you can't, you're okay. Yeah.
You know when we were talking earlier about the differences between a 510 and 6-1?
Yeah.
What if, for example, you can pick out this stuff about suggestion and reassurance, but your particular comparison is like 5-7 and 5-8? Do you think that you lose, A, credibility in arguing that, or B, that he's so close to the size of your client that it ends up pointing more to your client?
Yeah.
Do you abandon that then?
Not necessarily, because she raises a good question. Everybody here, okay, the description was, say, 5'8", and your defendant is 5'7", or vice versa. In other words, the description is close, okay? You've still got all of this business about suggestion and reassurance, because the mere fact that we're talking about 5'7", 5'8", and so forth isn't significant. How many men are there in this country who are 5'7" or 5'8"? And that's what the prosecution wants to do. They want to take somebody who is average height and say that because he's average height that we ought to convict him of robbery.
Not guilty.
I heard the question a little differently.
Oh, okay.
What do we do when we have one witness, 3 different descriptions, each description, height, for instance, maybe an inch or 2 off? Do we then lose credibility points by arguing those inconsistencies? He said 5'10" once, he said 5'11" the next time.
Oh, yeah.
Don't.
Oh, yeah. Okay, I haven't had all of you in the small section. Never operate by rules. Okay, rules are dull tools. Okay? You're going to trust your gut. Okay? This is what the law professors don't understand. Your guts are precision instruments. Okay? When in Group E yesterday we had cross-examinations using storytelling cross-examination, they went by their feeling as to who was winning, whether the cross-examiner was winning or the witness was winning. And they were right. Okay? So the law professor says, we teach you rules for 3 years. That's precision stuff. You just use these rules and you can analyze any situation and say how it ought to come out. Things like emotion, trusting your gut, and so forth, they have nothing but contempt for. They have it all backwards. The gut, your judgment, is the precision instrument. Rules cannot be used to do cases. So your gut tells you, I'm going to lose credibility with this jury if I argue 5'7", 5'8". But let's play with something a little bit on the 5'7" and 5'8". Let us say I am the person who is robbed, and I'm 5'9". And here we stand. Okay, the robber is here, I am here. And I give a description that is 1 inch taller than I say he's about 5'10". And it turns out that the defendant is 5'8". Okay, we're getting something significant here? Okay? That I said what? When I gave the description, he was taller than I am. Okay? And this is the man who is shorter. Sorry.
Look up to see his eyes.
That's right, he had to look up. See what we're doing? We're taking this particular identification and putting it under a microscope. So it is not whether it is 5'8", 5'9", 5'10", etc. What we're really dealing with is a very small area here. So at the Indianapolis 500, it isn't the fact that cars are going 220 miles an hour, 200 miles an hour, etc. It is relative to each other that makes the difference. That's the reason they don't crack up any more than they do. So in identification, we are dealing with situations that in general are right around, say, since men are the ones who commit crimes. We could go into why women are superior to men, but I won't do that here. But so we are dealing with, in general, something like 5'8" to 6'2", includes almost all men. Fair? So it's this much area that we are dealing with. You start examining that, and over again, you are going to be able to destroy the identification because the person is taller, shorter, etc. If I give a description that is taller than I am, it meant I had to look up. So if he turns out that he's shorter, I would have been looking down. And you take the firm position. It couldn't have been him. It couldn't have been this young man who did it, because the description was Wrench had to look up. It was a bigger man, and this young man is shorter. Okay? By the way, where are you going to get the information as to the different sizes and so forth? Do not get them from the witness. That is, the description. Get the description from the police officer. Why? Because that witness is going to tell you why. Well, you know, I'm not very good at heights and weights and that kind of thing, but what I know is he's the one who did it. Okay? So you're going to get the information that the description was 6'2", 180 pounds, and so forth, and you are not going to give the witness a chance to explain this. This was the description. This is how tall your defendant is. See what I mean by being a closing argument type of case? Identification is a closing argument type of case. Okay. Probably. Because what can you say about police officers? Police officers, see, they can never come in and take the position that they are superior human beings. Okay? Because of the arrogance part of it all. All police officers and the prosecutor claim that they're human beings. It means they can make mistakes. Go ahead. Yeah.
FBI sketch artists
Yeah.
have come up with a sketch, and it really looks like your man.
Yeah. Okay.
How would you deal with that?
First of all, I'll give you an example.
What do you mean?
There's no question there get to be tougher cases. I had a murder case, liquor store. One of the clerks there was an artist who wasn't able quite to make a living on the outside and needed to make a little extra money at the liquor store. He painted a picture of my client. I felt like going to my client and asking him how many pictures he wanted. But I'm faced with that kind of situation. what I would do is put a lot of focus on other things. Secondly, I would examine that picture compared to your defendant and see if there wasn't some difference, okay? Any difference whatsoever.
There's got to be, I mean, if you have a distinguishing mole, that'll probably be in the picture, but they're not going to have all the little freckles, all the little things, even though they have the capability of drawing them in. I'll bet your sketch artist didn't have the mole. The auto work artist, did they have the mole in the picture?
No. You just look.
I mean, that's pretty good.
Okay, but while we're on this subject, you hold your question a second. While we're on this subject, it always kind of embarrasses me to do that, but what you do with your defendant is you look your defendant over for anything whatsoever that is distinguishing about your defendant. Okay? That they should have noticed if he was really the robber, but they didn't notice, and they didn't put it in the descriptions. And you can say, ladies and gentlemen of the jury, if Johnny defendant had been the one with this prominent mole, scar, whatever it is that he has, anybody who was an eyewitness that could be relied on would have seen this. And this evidence shows that he could not have been the one. Because the real robber didn't have this scar, mole, whatever it was. Okay? See, you're always prosecuting the real robber. Throughout the case, you're prosecuting the real robber. In whatever small ways he happens to be different from your defendant. I remember one case, the lady described how the robber had these long fingers with fingernails that were, it was like a woman's fingernails. And I hadn't heard this before. And I looked at my defendant. Here are these long. Okay, yeah.
Yeah, on the relative height of the victim and
Right.
and the perpetrator, you get the cop to introduce the height of the perpetrator, but you do need to get the height of the alleged victim in. You just ask the victim how tall are you?
Yeah.
And then let it go.
Yeah. And so if I'm concerned about that, I just ask him at the hearing for his driver's license. And the amazing thing is that they'll give it to you.
Well, we can get even these.
And you can get them, yeah. But, you know, you don't want to alert the prosecutor too much to these things, although they don't seem to catch on. There was another question.
Any techniques that we can use to get out of the police officers' mouths the evidence of uncertainty? I had a situation recently where I subpoenaed the identifying witnesses. I didn't know their identity because they were all confidential informants, 3 of them, and I subpoenaed all 3. Federal court, the magistrate said, forget it, I'm just going to hear from the agents. Hearsay's acceptable. We're just going to hear the agents describe the photo lineup. All of my protests, you know, I preserved my objection, but I didn't get the witnesses. I only have the agents.
Okay. So we've got our agent here, and we want to know about the photo display.
Right.
Okay. They do not know what I'm talking about. Okay. So we go through the process that there was a photo display, and you showed him 6 pictures, as I recall, right? And you've given us the pictures. There were 6 pictures. Okay, you laid it out in front of him. You might. Would you? Okay, tell me how you did that. Now, by the way, what cross-examination technique are we using here? A little Columbo, huh? Okay. Just asking some questions here, detective. I got nothing better to do. and so we get it, which, so that after 4 you went ahead and looked at 5 and 6, okay? But suppose that that didn't happen, that is, no way or other were you able to get that in trial. We could safely do this, because it's one way or the other, right?
Well, in this instance, it was a photo lineup on, it was 6 laid out, which I know isn't supposed to be the proper method, and I might be able to get that in at trial, but it was 6 laid out, so it wasn't that the witness went through one at
Right.
a time. It was, she looked, she pointed,
Yeah,
say anything? No, she just pointed to the right one right away, and how long it, nothing I was able to do got me any of the uncertainty in that hearing.
okay. But, you see, they didn't, I haven't thought about your situation, but the thing's not done, okay? So the detectives didn't carry out the process the way they should have carried out the process with all of the safety and the care of the whole thing.
Well, it's interesting, they had a protocol, I think it was a DEA protocol that they followed, and the DEA protocol is wrong, according to what experts have told me, but that's going to require bringing in an expert, I think.
Okay, or,
We may not
and if you have an expert, but if you don't have an expert, no, you just argue and argue with chutzpah, okay? That the DEA has had the wrong procedure for doing this for 18 years. They haven't changed since 19 da-da-da-da-da-da. And you, ladies and gentlemen of the jury, can see this, okay? And then show it to them. Okay, you answer the question? Okay. Now, in the closing argument, we have built various blocks for the closing argument, right? We've built a block on the inconsistencies as showing that Campbell can be wrong. We have a block as to vague description. We have a block as to uncertainty. The certainty has occurred here in the courtroom. We have a block where we answer the question, ladies and gentlemen of the jury, how did it occur that we went from uncertainty to certainty? It was through a process of suggestion and reassurance, and you'll lay it out for them, right there in closing argument. Okay? Now, you are operating on the basis that this is an innocent man, okay? And we need you to come up with your own version of what I'm just going to do for you that creates fear on the part of the jurors about the possibility of convicting an innocent man. Okay? What I do in these cases, unless I have some time to tailor something else or what have you, is to say to the jurors, you know, I mentioned instruction about reasonable doubt. But then I say to the jurors that this instruction, as a matter of fact, everything that we have done during this entire trial has been for one purpose, and one purpose only. And that's to be sure that no innocent person is going to be unjustly convicted. That's all I ask of you. That's all Johnny defendant asks of you. But when you finish your deliberation, you can say in your heart and in your conscience, no innocent person is unjustly convicted. And you do the right thing. Any other questions? Yeah.
How would you deal with, characteristic. And you've got a 6'2", 5'8", you've got a star, you've got something like that.
Benfield? Okay, so you're reversing it and saying they've got the scar, or what have you.
My client has a scar in the description of the scar or a and whatever you're going to take. No, it's not taking a place.
The one thing I know is that what has happened is that the witness focused on the scar, are focused on this gold tooth, and jumped to the conclusion when they saw Johnny defended that he must be the one simply because he had a gold tooth. And so what the prosecutor is trying to do here is to convict him because he has a gold tooth, not because he's a robber. I told you this business is fun. Just don't do it the way the law professor is taught, okay? Do it the way that it's really fun. I'm going to be leaving, and I want to tell you, I have enjoyed royally all of you. You're great. Go home and really do it, okay? Leave all the personal antagonisms and so forth out of it, because there are so many powerful things that you can do, okay? Next time you have a defendant, what you know is that defendant is not guilty. Then start working. Not on how tough the case is or anything like that. You start working on the next line. He is not guilty because, and put your imaginations to work, okay? That's all I was doing today, just putting imagination to work. A lot of the things you asked about, I had never thought about before, okay? Put your imaginations to work. Create a fear of convicting an innocent person, and you can win the criminal cases, okay? And I do applaud you for what you've done this week.